So, friends, they're at it again. Donald Trump and his lawyers have filed yet another motion trying to delay the start of his first criminal prosecution. And they're arguing in substance that there's just too darn much publicity surrounding this trial. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. Well, friends, yet again, Donald Trump and his lawyers have filed a motion in Trump's criminal case in New York, which is scheduled to begin on April 15th. And again, they are trying to, are you sitting down? Delay the commencement of the trial. Well, we're going to start with some of the new reporting, and then we're going to have a look at just a little bit of this new defense motion, and we're going to have a good laugh together, because this is one ridiculous argument made by Donald Trump's attorneys. Let's start with the new reporting. This from the Business Insider. Headline: Trump complains in latest hush money delay bid that Manhattan already thinks he's guilty. And Michael Cohen keeps calling Donald Trump names. As you can see, friends, I'm paraphrasing that part of the headline. The article begins, Donald Trump's lawyers are trying again to delay his hush money trial, this time arguing that pretrial publicity and the demonstrable anti-Trump prejudice of Manhattan residents will make it impossible to get a fair jury trial anytime in April. Because I guess they've concluded that, come May, all of the anti-Trump folks intend to move out of Manhattan, and a whole slew of pro-Trump folks will be moving in. My editorial edition. The article continues, quote, President Trump's constitutional right to a fair trial is at stake, the defense says in a March 18 delay motion that is now before the trial judge, New York Supreme Court Justice Juan Merchan. This 11th hour effort to push back Trump's April 15th trial date is the latest of a half a dozen such requests since August. Clearly, Team Trump has been busy, and on a granular level. They've hired pollsters who found that 61% of Manhattan potential jurors already believe Trump is guilty of something, nearly twice the rate of surrounding counties. An uphill battle. Meanwhile, prosecutors, who must respond by Monday, seem ready to throw a lake's worth of cold water on the defense effort, which is formally titled President Donald J. Trump's motion for a further adjournment based on prejudicial pretrial publicity. This from one of the prosecutors. First, publicity is not likely to abate. Assistant District Attorney Matthew Colangelo argued the last time everyone was in court on March 25th. And friends, the article goes on to talk about some of Donald Trump's complaints that people like Michael Cohen and Stormy Daniels and others are calling him mean names. And they're suggesting that he committed crimes. Problem is, Donald, you have committed crimes. And the accurate reporting about just some of the evidence makes it clear that you committed crimes in violation of New York state law, not to mention Georgia's state law and federal law. Well, friends, let's turn to the motion that Trump's lawyers just filed, and let's just take on two of the arguments, two of the many absurd arguments offered by Donald Trump's lawyers about why he just can't possibly go to trial, especially not right now. So this motion in the case of the people of the state of New York against Donald Trump defendant is titled President Donald J. Trump's motion for a further adjournment based on prejudicial pretrial publicity. And right there in the title, there's a typo. It should read Defendant Donald Trump's motion because he's not president. He's the defendant in this case. Let's turn to the introduction. President Donald J. Trump respectfully submits this motion for a further adjournment of the trial date in light of exceptionally prejudicial pretrial publicity, which is substantial, ongoing, and likely to increase. Okay, friends, can we take on that last clause, that last argument by Donald Trump's attorneys, who are really not very good at this lawyering thing? They actually argue that because the publicity is likely to increase, that's a reason to delay the trial. That's a reason not to start the trial on April 15th, as previously set and reaffirmed by Judge Merchan. No, because the publicity is likely to increase. So let's kick the trial well down the road when all the publicity is likely to subside or maybe just evaporate altogether. No one will have interest in this prosecution if we can just continue the case until a later date. Yeah, that's absurd. That's laughable. In fact, if I were the prosecutor, I would use that claim against the defense. Listen, they said this publicity is likely to increase as time goes on. So, Judge, let's get this trial up and running. Because, as they say, publicity is only likely to increase. Let's get this trial in the books. Let's start on April 15th. Let's let the jury resolve it. Because, as the defense says, if we don't, publicity is only likely to increase. It's nonsensical. It's an absurd argument. Let's take on another absurd argument. They go on to say in Defendant Trump's motion, based on a survey that included a sample of 400 residents from each of the New York, Orange, Richmond, Rockland, and Suffolk counties, which is attached as an exhibit, it's clear that potential jurors in Manhattan have been exposed to huge amounts of bias and unfair media coverage relating to this case. And many of the potential jurors already wrongfully believe that President Trump is guilty. Do I even have to unravel and mock that one? You see what they're saying there? They're saying that people who are actually paying attention to the news, the reporting, and evaluating accurate information for themselves are concluding that Donald Trump is guilty of the crimes for which he's been indicted. He actually committed the offenses that he's about to stand trial for. And you know, Judge, we can't have that. How can we have an informed jury pool that has evaluated the evidence that they've seen reported and have reached conclusions that Donald Trump is guilty? You know, friends, I think one of the things this highlights, and I think one of the things that Trump's attorneys are trying to get at here, they will fail. These are losing arguments, and Judge Merchan, I am almost positive, will reject them promptly and perhaps summarily. But they're trying to get at this notion of the presumption of innocence, right? Because all of these jurors already think Donald Trump is guilty. Well, they're evaluating the evidence, and they've seen some of what Donald Trump does with their own eyes, the Access Hollywood tape, his incessant statements and posts where he screams his own consciousness of guilt, right? His, not wanting to mix criminal apples and oranges. We saw him launch an attack on the U.S. Capitol. So, of course, we've reached informed decisions that Donald Trump is guilty of crimes, both state and federal. But isn't he presumed innocent? The answer is, for the most part, no. The presumption of innocence, and I wrote a piece about this literally years ago, when Donald Trump was making some other inane claims about people not presuming him innocent. I will put a link to that piece that I wrote for MSNBC several years back regarding the presumption of innocence and where it actually applies in our criminal justice system. But first and foremost, the presumption of innocence doesn't apply to the court of public opinion. To the contrary, we are receiving information all day, every day from lots of sources, some reliable, some not so reliable, some spewing just outright lies and misinformation and propaganda for their own nefarious purposes. Some of the faux news outlets, for example, some of the, the Russian bots and the Russian assets and operatives who have infiltrated social media at virtually every level, and they keep pushing disinformation on the American people. But we receive information from lots of sources. And what we do is we apply our understanding of human nature, we apply our common lived experiences, and we reach conclusions based on what we see, what we learn, as to whether Donald Trump committed crimes. He did. The evidence, once we get into trial, it's going to be overwhelming that he committed the crimes for which he's indicted. I contend in both state court jurisdictions and both federal court jurisdictions. And there is no presumption of innocence in the public square, in the court of public opinion. Here's the part that people might not know. The presumption of innocence in the criminal justice system only applies in one place, inside the courtroom when the case is going to trial. Not even inside the courtroom at all of the hearings in the run-up to trial. Not at the presentment hearing, not at the arraignment hearing, not at the preliminary hearing, which is often a detention hearing, not at motions hearings to litigate motions as to whether evidence will be admissible or not. The presumption of innocence plays no role in any of those hearings. Here is where the presumption of innocence comes into play in our system. When jurors are being selected, they will be asked by the judge, is there anybody here, knowing what you know about Donald Trump, about his alleged crimes, about the indictment in this case, and anything you might have heard in the media, social media, from friends, from acquaintances, from any source, is there anybody here who is unable to set all of that aside and to presume Donald Trump is innocent, is not guilty of the crimes for which he's indicted? Because you're required to do that, ladies and gentlemen. You have to presume the defendant is innocent. And you can't convict a defendant. You can't vote guilty unless and until the prosecution, the government, has proved every element of a crime beyond a reasonable doubt. The presumption of innocence follows the defendant throughout the trial unless and until his guilt is proved beyond a reasonable doubt. Is there anybody here who can't apply that legal mandate that I'm giving you to presume the defendant not guilty, innocent of all charges? And that's how you weed out some of the jurors. Because if the jurors say, I can't do that, I know too much, it's too firmly entrenched in my mind, then they're not capable of sitting as a fair, impartial juror in the case. This is exercises that we, the prosecutors and defense attorneys, go through every day in every jurisdiction across the country. Now, here's the other place it applies. We just talked about during jury selection to try to weed out jurors who can sit or who shouldn't sit because they can't be fair and impartial and they can't apply the presumption of innocence. Once the jury is sworn, you have 12 people sitting in that wooden box as the conscience of the community, a jury of Donald Trump's peers, and they're going to decide Donald Trump's fate. After they're sworn in, the 12 jurors and a series of alternate jurors, the judge tells them, now, you must presume the defendant innocent. And that presumption follows the defendant throughout the trial, unless and until the prosecution proves beyond a reasonable doubt every element of a crime with which he is charged. That is your sworn legal duty. And the trial commences. Ladies and gentlemen, now I'm talking to the jury again. Gosh, I miss jury work. Friends, ladies and gentlemen, that's where the presumption of innocence applies. In the courtroom at the time of trial, during jury selection, and after the jury is sworn in and the presentation of the evidence begins. That's when you must, under our system. And in many ways, it's a great system. In many ways, it needs to be retooled, reworked, rebuilt. But that is where the presumption of innocence applies. So Donald Trump's lawyers complaining that many of the jurors in Manhattan seem to have made up their mind. They think Donald Trump committed crimes. So Donald Trump's lawyers complaining that, you know, many of the potential jurors, the folks in Manhattan who could be called for jury service, have assessed and evaluated the information and the evidence that they've learned. They've determined it to be reliable, and they believe Donald Trump committed crimes. You know, those complaints can and will fall on deaf ears, Judge Merchan's ears, because that's not a reason to continue the trial to a later date, particularly when the defense attorneys say publicity is only going to increase. So even more jurors, if they continue to take in reliable information, will reach the correct conclusion that Donald Trump committed crimes. Nonsensical, absurd, ridiculous. All of that characterizes this latest motion filed by Donald Trump and his lawyers, and I strongly suspect Judge Merchan will again, for the I don't know how many times now, will again refuse to continue this trial. Jury selection will commence on April 15th, and as I've said before, based on the available evidence, and remember, we don't know all the evidence the prosecutors have, nor do we know what the defense will be. But based on what we do know, and there's been a lot of reporting, I believe Donald Trump will end up being convicted of the dozens of falsifying business records crimes on which he's been indicted, probably by sometime late May. And that is as it should be. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.